Thank you. Thanks, Rafael, and thanks everyone else at the center here for organizing this, and thanks for being here. It's a privilege. I suppose in a way, I have two roles here. I'm an academic today, and tomorrow I'm maybe a bit more of a board member of the Finnish Animal Rights Law Society, because I'm also a member there, which we'll be discussing tomorrow. So those of you who maybe work in the same academic space as I do might think when you see this title like, oh no, not again. Like I've been doing this same stuff for like 10 years now. Well, you should blame Saskia Stucki, because she was basically, we had this interaction maybe May or June, when she was basically pushing me that I should, because my sort of writings on this are sort of scattered around different places, and I should like write a definitive paper where I make this argument. And I will actually be criticizing Saskia quite a bit in this paper, and I thought she would be here. It's a bit unfortunate she isn't. Yeah. But I did send her actually the draft paper and also these slides, so we'll see what she has to say tomorrow. So yeah, I guess I was already introduced, but I do animal law and legal personhood and rights theory, all of those sort of related to each other. I had some interest outside of animal law as well, like things like what I've started calling attention rights, and we've got a project on what's called agency in law, and we recently published something on that with Paulina Semjenec. But I decided not to talk about that because I think this topic felt more closely related to the conference here, so I'll rather be talking about rights theory. And as Rafael already mentioned, we have a Helsinki Animal Law Centre in Helsinki, surprisingly, which has all kinds of events. It's a rather big hub of people working on different topics around animal law. You're also welcome to visit us if you want to. If you're interested in agency, we might even be able to help you out financially a little bit. If not, it might be more difficult. So what will I be talking about here? First, I'll give a brief introduction to the topic. Then I'll actually do a bit of intellectual history of what Rafael already this morning called thin rights. Then I'll give some replies to Stucki's skeptical points about thin rights, and then I'll discuss the role of legislative and judicial language in rights, in animal rights. So, start with a question. We have a law that says dog owners should legally give food and water to their dogs every day. Give me a show of hands. How many here think that the dogs have the right to receive food and water every day? Okay, so most of you. Okay, all right. This is the question that we'll be discussing today. What about this then? Cows should be stunned before slaughter. How many here think that cows have the right to be stunned before slaughter? Yeah, okay, not quite as many of you. Okay, interesting. So I think in current legal theory in this space, there are roughly two positions. And by the way, I'm maybe here working on the sort of more traditional welfare laws that most Western countries still have. So of course we have these special cases where we already have explicit recognition of animal rights in some countries. But I'm sort of more working in I think how it works in most European countries, that we have animal protection laws that do not talk about animal rights. It's only about protection. So legal theorists today, I think, quite a few think that animals do not hold legal rights, and there are various reasons. One reason is that animals are not protected strongly enough. This is what I come to call the strong rights or no rights thesis. Or because the law has not given them rights explicitly, so the law doesn't talk about animal rights, because animals are not legal persons, or because they cannot demand their rights. So this is sort of the will theory approach to rights. And this could be maybe called the traditional view. And then there's this alternative view according to which animals already hold some limited legal rights, because even weak protections can entail rights. because the language of animal protection statutes is not relevant, because one can hold legal rights without being a legal person, and because rights are about interest and not demand, so as opposed to the will theory. And when I got interested in this maybe 14 years ago, I sort of felt persuaded by this position too, and I wanted to argue for it. And I thought it was being novel. I thought it was like a new thing. But actually, it's like 200 years old, unfortunately. So I'm going to be talking about that a little bit. In an earlier version of this slide, I called that the new view, but I will call it the alternative view because it's not new. So I think the sort of debate centers roughly around three sort of topics. On the left-hand side, we have the question of legal personhood or legal subjectivity. So is it a precondition for rights that you are first declared a legal person, or is it more like that you're given rights and then you become a person or a subject? So I'm not going to be talking about that a lot. I'm happy to discuss that in the Q&A, but that's not really the focus of this talk. What I will be talking about is the question of sort of simple versus thick, or I mean thin versus thick, or simple versus fundamental rights. So what kind of rights do we need in order to really call them rights? And then a little bit I'll be discussing the will versus interest theory debate as well, but not a whole lot. Some caveats. This is an examination of legal welfarism. It's not a defense of legal welfarism. There will be a lot of white men, unfortunately. There will be some intellectual history and European legal history. And this is definitely work in progress. I have a very early draft paper that I'm a bit hesitant to even share with you at this point. So I'm definitely welcome any feedback. So in I would say a seminal article by Saskia Stucki, Towards the Theory of Legal Animal Rights, Simple and Fundamental Rights, Saskia makes this distinction between simple and fundamental rights, especially as applied to animal law. And roughly, the idea is that simple rights are the kinds of rights that animals hold as a result of animal protection laws, whereas fundamental rights, I mean, Raphael was going through it this morning. Of course, Raphael and Sean's points or like definition is a bit different, but it's roughly that fundamental rights protect fundamental interests, they're not easily infringible, and they have certain procedural benefits, so for instance, standing. And there are some other things that Saskia talks about, but this is roughly what she means, just as a way of introduction. And I think like this distinction has gotten a lot of traction in animal law literature, but if you read the article, Saskia is actually quite lukewarm about simple rights, even though she first introduces it, but then she's like, yeah, I don't really know if simple rights are rights, actually. So she writes, for instance, while theorists can show that a rights-based approach lies within the bounds of a justifiable interpretation of the law, an actual valid legal right hardly comes to exist by the mere fact that some theorists claim it exists. And there are substantive reasons for questioning whether the kind of rights extractable from animal welfare laws are really rights at all. So it seems to me that Stucki seems to treat fundamental rights as the primary type of rights, and simple rights are maybe some kind of abomination that people who take Hofeld too seriously have come up with. But I hope to show that simple rights actually have a long history. This way of thinking about rights has a long history, and I would say that it's an established type of rights. I'm not saying that simple rights are sort of primary to fundamental rights, but that it is definitely like a respectable way of thinking about rights. I'll start by noting that David Brink, who is a political philosopher, he's recently published a paper, I think I forgot to add the reference, it's something like Two Conceptions of Right. So he recently published a paper where he makes a distinction between contributory rights and conclusive rights. I've also, in my earlier work, made a distinction between rights as reasons and rights as conclusions. But I think Brink's work here is quite useful. So he makes a distinction between the kinds of rights that we use when we engage in legal reasoning. So I think most lawyers here can think of, for instance, fundamental rights. So when you do legal reasoning, you use fundamental rights. You use them to reach a conclusion about what the law says. But then on the other hand, when you have a trial or something, there is a right that results from the trial. So the court declares that, okay, this is like this, you were demanding something, but you do not have the right to this thing, or something like that. And that would be like a conclusive right. So just to compare this a little bit, contributory rights are inputs into normative, so moral or legal or whatever reasoning, whereas conclusive rights are conclusions of debates about the entitlements of individuals. Contributory rights typically are especially important contributory factors that typically control the resolution of the practical situation in which they are present. So again, think of constitutional rights as lawyers. When they come into play, they are very important reasons for reaching a particular outcome. Whereas here is John Oberdig, who makes the exact opposite point, that the central role of rights in normative argument is conclusory. People argue toward rights, not from them. Okay, so this is the exact opposite way of thinking about rights. I think in philosophy, if you talk about rights-based something, rights-based, political philosophy, rights-based ethics, this is usually some kind of contributory idea of rights. And the same goes for law when we talk about constitutional rights, but also so-called human rights. Whereas I would say that conclusive rights can arise out of all kinds of legal materials, not just, for instance, constitutions. So we have statutes, decrees, constitutional provisions. They go through this process of legal interpretation and so on, and as a result, we have rights in some particular case, for instance. So I'm now going to go through a little bit of intellectual history of this conclusive or thin way of understanding rights. So some people who, I would argue, put forth this kind of way of thinking about rights include Jerry Bentham, John Stuart Mill, John Austin, Henry Salt, René de Mock, Alf Ross, H.L.A. Hart. I won't be going through all of them. I'll be discussing Bentham, Salt, de Mock, Ross, Hart, and also John Chipman Gray, actually. And actually, this came as a bit of a surprise to me when I started doing this research, but some of them explicitly discuss animal rights as well. So Bentham, he might be your hero because you're animal rights lawyers, but he also has this interesting definition of right. To know how to expound a right, carry your eye to the act which in the circumstances in question would be a violation of that right. The law creates the right by forbidding that act. If you're into legal theory, there's something called Bentham's test, which is a very boring technical debate that I'm a part of. So this is the start of that discussion. But more generally, Bentham makes the point that we can create rights by prohibiting something. So for instance, if we prohibit murder, we're creating the right not to be murdered. So since Bentham was a hero of animal ethics and rights, so did he apply this to animals? Did he already think that animals hold rights as a result of this? Well, it's a bit of a mixed bag. I read an interesting paper recently which argued that Bentham's animal ethics is really, really quite modest. It's not radical at all. I mean, it may be radical in the context that he was in, but it's really a modest form of anti-cruelty. So Bentham, this is from an article by Johannes Knies. So according to Knies, and there's a lot of Bentham quotes here, animal suffering is justified whenever it serves a useful purpose, for example, in the way of food, physic, clothing, conveyance, or manufacture, as part of experiments to promote medical or other useful knowledge, as way of chastisement, or to defend any person or thing from being hurt or annoyed. So it's quite modest. But I recommend the paper. He has some hypotheses about why Bentham thought this way. But I mean, you usually see the quote about, the day will come when, animals will be liberated and so on. But this is a rather different picture of Bentham's ethics. But he still had this view about rights. So what did he think of animal rights? He actually wrote about it when he was 78 in a manuscript. that I found because of Knie's article. So he writes that the only possessor of a right is a person. To speak of a thing as possessing a right is absurdity and nonsense. In a large sense, animals endowed with sensation are termed things, and those so termed in a moral sense may be said to have a right to be well treated. So this is interesting. This is like a welfare right. You have a right because there is a duty to treat you well, insofar as it's consistent with the use which men need to make of them. But yet in a legal sense, no such thing can be said to have a right, at any rate a right exercisable by himself, though by any man in quality of its guardian, a right may be exercised in behalf of the thing. So I think it's a bit sort of contradictory here. First he says that animals cannot hold legal rights, but then he says, well, actually they can if they have representatives. So I'm not sure what to think of this, to be honest. But I think Bentham at least did not hold the strong rights or no rights position. He thought that even this sort of a very modest duty to sometimes not inflict suffering of animals entails a right for the animals, at least a moral right. And then we have Henry Salt. Maybe some of you have heard of him. He was like a public intellectual in the 19th century. So after Britain had passed Martin's Act in 1822, he wrote, I mean this is like 70 years after, that it is scarcely possible in the face of this legislation to maintain that rights are a privilege with which none but human beings can be invested. So again, it seems to me that for Salt, an Animal Welfare Act resulted in rights for animals. Of course, modest rights, but still. Now we move to the European continent for a bit, and we'll get back to UK in a couple of slides. But Rudolf von Jhering, who is a relatively famous German legal scholar, presented an interest theory of rights in 1872, and he actually held the strong rights or no rights position. So he held that this does not result in rights for animals, because that would mean that we would have to stop all kinds of animal use. So he held that position. But then we have two interesting sort of legal scholars who were inspired by his work. René de Mogh in France, who wrote a treatise of private law, and argued that animals can be subject to private law. So he's got this idea of what I think in common law would roughly be pet trust. He thought that animals can hold rights in these kinds of cases. And then Alf Ross, one of the great Scandinavian legal realists, wrote in his 1936 doctoral dissertation, Virkelighed og gyldighed i retslæren, that's my best Danish, that this means something like reality and validity in jurisprudence. So he wrote explicitly that animal protection laws give rights to animals. I think this is the most explicit thing I could find. And I thought I was being novel 10 years ago, but actually Ross said this like 90 years ago. And by the way, that's available online. I'm sure there's like tools to translate it if you're interested. Because the discussion, I think, like anticipates a lot of more recent animal rights discussions. Like he makes these comparisons to children, for instance, like, that animals cannot maybe exercise their rights, but children can, and he's got this distinction between the beneficiaries of rights and administrators of rights, and it's really quite modern in my opinion. And Ross doesn't seem to be motivated by animal ethics in any way. He just wants to have a clear system, like a consistent system. I know if you don't want to read the Danish, you can take a look at On Law and Justice, which is his magnum opus. But in that book, he only discusses the private law side. He doesn't discuss the animal welfare law side. And then just a couple more people, and then we'll end with the intellectual history part. So there were two Anglophone scholars who seemed rather to think that animal protection laws, even if they are quite weak, would entail rights for animals if animals could demand their rights, or if someone could sort of represent them and demand rights for them. So they were not worried about the weakness of welfarist protections. So here we have Gray saying that the interests of brute animals may have legal protection, yet beasts have no legal rights because it is not on their motion that this protection is called for. And Hart, one of the greatest legal philosophers of the 20th century, well, first of all, he clearly had this conclusive idea of a right. He wrote that A has a right, like he is out, is the tail end of a simple legal calculation. It records a result, and maybe it will be called a conclusion of law. So Hart clearly held this position about rights. And in 1982, he wrote that, because he was a will theorist, so he thought that you need to be able to demand your rights. The will theory provides an explanation of the fact that animals, even though directly protected by the duties of criminal law prohibiting cruelty to them, are not spoken of or thought of as having rights. So again, he was not bothered by the weakness of these protections. He was bothered by something else, which was that animals cannot demand their rights. And then there are these more recent examples, like Claire McCausland, Cass Sunstein, and Matthew Liebman quite recently also sort of argued in favor of the view that animals already hold rights. So this is maybe a bit unfair to Saskia, but she writes that, again in the same article, that classifying animals' existing legal protections as rights may thus conflict with the deeply held view that because they protect interests of special importance, legal rights carry special normative force. But I would really ask, is this a deeply held view? We have really like a 200-year history where legal rights do not necessarily protect interests of special importance. Fundamental rights normally do, but not all rights do that. So just to summarize what I've sort of tried to say so far, so there is something like a thin rights tradition in Western legal scholarship, which presents rights as simple correlatives of duties. There is also like a thick rights tradition, which, for instance, Raphael has investigated in his PhD dissertation. But there is definitely a thin rights tradition as well. And I would say that roughly what this tradition amounts to, or what its sort of method amounts to, is that we discover legal rights by engaging in legal reasoning, reaching conclusions about the content of the law, and considering who or what is protected by the law. And assuming that entity can hold rights, so has the interests, then that entity presumably is a right holder. And these interests do not need to be sort of important or fundamental or anything like that. They can also be trivial if the law chooses to protect trivial interests. And I think one interesting thing is that in the case of welfarism, the trivial human interest often trumps central animal interest. So that's actually one case where law tends to protect trivial interests when it compares human and animal interests or weighs them against each other. So that was the sort of historical background, and this is now framed as replies to Stucki, because I was using her article as sort of how I was building both my article and or my paper and this presentation. So in the sort of fundamental or thick rights tradition, you often have this idea that rights single out interests not to be sacrificed to the utilitarian calculus. This might sound familiar to many of you. So this is something that rights are the things that protect us from being sacrificed for something that would benefit the common good. But I disagree, again, from the thin rights perspective. So one right that has been quite relevant for me recently is the right to daycare. I think the right to daycare can definitely be the result of a social calculus of interest. So, there are various social reasons why we might want to have publicly subsidized daycare. For instance, getting more women to the workforce, this has traditionally been one of the reasons, and more tax revenue and those kinds of reasons. But that would still entail the right to daycare. And then we get to the sort of analysis of different types of welfare rights, or welfare protections, I should maybe say. So Stucki singles out two types of rights that animal welfare laws typically contain. So there are rights that protect sort of, well, I'll just quote here, that they have a narrow substantive scope protecting highly specific secondary interests, such as a relative right to be slaughtered with prior stunning. And then there are these broad welfare provisions that are watered down significantly, and I'll get to both of these in a moment. So first, these narrow welfare rights. So Stucky has two examples: the right to be slaughtered with prior stunning and the right of chicks to be killed by fast-acting methods such as homogenization or gassing. Well, that's pretty rough, right? Do we really want to say that that's right? So Stucky then writes, while these rights may protect certain secondary derivative interests, such as the interest in being killed in a painless manner, they are simultaneously premised on the permissibility of harming the more primary interest at stake, such as the interest in not being killed at all. So there's the secondary interest or derivative interest of being killed in a painless manner, and then there's the primary interest of not being killed at all. So I have a bunch of issues with this characterization. Oh, that's a weird order. First, how she describes these rights. Second, that she's picked rather gruesome examples, and how she describes the interest here. So first, the description of these rights. I mean, this is sort of a, nitpicking, but it's not the right to be slaughtered with prior stunning. It's the right not to be slaughtered without prior stunning. I think there is a difference there. Because if you have the right to be slaughtered, that means that someone else has a duty to slaughter you, and probably they don't. They can choose not to slaughter you. But that's maybe a minor issue. But I do take issue with the examples she chooses, because, I mean, these kinds of rights, they sound pretty bad. I would still say they're right, but I can understand why they, as intuition pumps, they may lead us to think that, okay, that maybe that's not a right. But she could have also chosen this example. Mammals and birds kept as companion animals have the right to constant access to water. I mean, that doesn't sound as bad, right? And then I think this is maybe my main contention here. So Stucky claims that the protected interest is the interest in being killed in a painless manner, and this is then a secondary interest. But I think it's kind of almost like ridiculous to say that you have an interest in being killed. Of course, there might be cases. In fact, some probably factory farmed animals have an interest in being killed. That's plausible, but I think the interest that is protected here is not the interest in being killed in a painless manner. It's the interest in not feeling pain, and I think that is a primary interest, or at least there is some broader interest, like an interest in well-being or whatever you want to call it, and I think that's a primary interest. So it's not that welfare laws protect secondary interests, but rather they protect primary interests, but imperfectly. Okay, they don't protect them very well, but they protect primary interests. And I think this applies to many of human rights as well. I mean, not human rights as thick rights, but human rights understood as the rights of humans. We often have rights that protect our interests imperfectly in various ways. Then Stucky discusses broad welfare rights. So this would be something like, I mean, many animal welfare laws have these very nice sounding provisions in the beginning, like that animals should be treated well and not subjected to unnecessary suffering or something like that. And then we can ask, well, does this entail a right? Does this entail that the animals have the right not to be subjected to unnecessary suffering? And here Stucky writes that although the object of such rights is of a more fundamental nature, the substantive guarantee of these facially fundamental rights is to a great extent eroded by a conspicuously low threshold for permissible infringements. Okay, that's a mouthful, but I mostly agree with Stucky. But there's one thing, which is this, that if we now think of rights the way HLA Hart, for instance, thinks of rights, so it's a conclusion of law. Rights are what we get after we've done the legal reasoning. So it'll look something like this. We have a statute that says it is prohibited to afflict animals with unnecessary suffering, okay? But this is not the norm. This is not, the right is not entailed by this statute. Rather, we need to do interpretation. Probably it will be very anthropocentric for various reasons. Judges are trained in an anthropocentric legal culture. there's like all these fundamental rights of humans that may restrict the interpretation of these statutes and so on. And so we have the resulting norm, which is something like animal suffering is prohibited in certain narrow contexts. See, I mean, that's really what it's about. And I think like a lot of doctrinal animal law is trying to figure out what exactly is this unnecessary suffering and what does it really cover. And it's this norm that entails then the right not to be subjected to suffering in context C. So I mean, I agree with Saskia that it's at least misleading to say that animals have the right not to be afflicted with unnecessary suffering. It's at least misleading because that's a very particular way of using those terms. You know, it's like you need to understand the legal context, and it'll probably sound much better if you tell a layperson that animals have the right not to be subjected to unnecessary suffering than if you tell someone who knows how it actually works. And then there is, and I'm quite interested in hearing what you here think about this, but I think there is a group of welfarist protections that Stuki does not address, and I think is quite interesting here. And that's basically that there are, most animals actually, I mean, it depends on the legal system a lot, they have significant prohibitions against how they can be used. So if you think of fur farming, for instance, I mean, it's prohibited in many countries, so animals cannot be used for fur farming. According to Finnish law, only 40 species of mammals and birds may be used as so-called production animals. So in a way, all other species have the right against being used as production animals. And of course, wildlife law has even more wide-ranging protections if you think of like the European Habitats Directive and so on. But that's the question is that a different kind of law? It's maybe not a welfare law. And here if you use, Robert Nozick has a idea of rights as side constraints. So this is how Nozick writes about side constraints. They express the inviolability of others in the ways they specify. These modes of inviolability are expressed by the following injunction: don't use people in specified ways. It doesn't say that don't use people at all. Nozick actually says that that's like a ridiculously high bar, that you couldn't use people at all. It's don't use people in specified ways. And this, to me, seems to meet the criteria of side constraints. Don't use dogs as, factory farm animals. And this even seems to me, probably at least in many Western countries where dog eating is shunned, these are probably relatively well enforced as well. So it's not just law on paper or law in books. I think if there was a factory that would farm dogs, I think that would get shut down very quickly in most Western countries. So I've here tried to sort of, by arguing against Stuki, to show why I think there is reasonable argument that welfare protections entail rights for animals. Again, I'm not trying to sort of justify the current welfarist regime in any way. I've just tried to examine it. Then to conclude, I'll briefly discuss the role of legislative and judicial language in all of this. So we've talked about this quite a bit today. I was, for instance, quite struck how openly it seems Spanish law and Spanish authorities use the term animal rights. It was quite interesting to see. But I think it's not necessary for authorities to talk of animal rights. Like, it's not necessary that judges talk of animal rights or that the legislature talks of animal rights in order for such rights to exist. Because legislative and judicial language is often very inconsistent. And I'll just show you, I'll try to show this through a couple of examples. First of all, the reasons why the legislator chooses to use some word may be various and multifarious. It might be that it's so obvious that there is a right here, for instance. So here is just one, maybe a little silly example, but it's the Finnish Tort Act. So there's two kinds of damage. There's personal damage, and when the law talks about personal damage, it says that one who has suffered personal damage has the right to blah, blah, blah. But then when it talks about property damage, it says that damages for property damage shall cover the blah, blah, blah. And really these are, if you ask any Finnish lawyer, both entail rights. If you suffer personal damage, you have the right to blah, blah, blah. If you suffer property damage, you have rights to blah, blah, blah. The legislature has just, for some reason of convenience, chosen to use different words here. It's not obvious that this is any sort of any implications for the question of rights. Here's another Finnish example. Sorry for being so parochial. But I think this is quite funny. This was actually spotted by Veera Koponen, who is one of our doctoral researchers in Helsinki, so she will be defending soon. So in the preparatory works of the Animal Welfare Act, so there is first this part, which says that, by the way, preparatory works are sort of considered to be authoritative in Finland. So they first write that the legally enshrined principle of respect for animals based on the intrinsic value of animals would not make the animal into a subject of rights. So it says quite explicitly that animals will not receive rights as a result of this bill. And then if you read like 100 more pages, then you'll encounter this. If legislators were to protect only the right to privacy, the authority's ability to oversee compliance with animals' rights would be weak. So even the legislature itself is inconsistent about this. It talks about animal rights at one point, then in the other point, or another part, it declines or sort of prohibits talk of animal rights. It's really, we shouldn't really trust the legislature on this, to be honest. So, I mean, this was not really a theoretical argument here. I was just trying to show you through a couple of examples why the legislature is sort of an unreliable source for us. And by the way, as far as I know, most jurisdictions don't have like official definitions of what it even means what right even means. That's usually been the task of legal scholarship, legal theory to figure out what this means. But I'll end by discussing the sort of why I think the legal language is still important in different ways. So why it's still important that we would get the judges and the legislators and so on to start talking about animal rights and not just animal protection. Of course, this is a little bit speculative because it depends on some practical sort of guesses or assumptions that I'm making in the background. But I think talk of animal rights, that animals already hold rights, so this chips away at the old person thing dichotomy. So I got a theory of legal personhood, and it's sort of this right-hand side here. So there's this what I would call the orthodox view on the left-hand side, which makes this stark distinction between persons and things, and you sort of need to be made into a legal person. You need to overcome this millennial barrier to become a person, to receive rights. But I would say that these are much more sort of gradual categories. And I would argue, for instance, that animals have moved a little bit from thinghood toward personhood. Just a little bit. I wouldn't say they're persons because you would need to be closer to here. But they've definitely received some rights. And I think that's a much easier way, like a much easier sort of stepping stone to argue for more rights if animals already have some rights. I'll get back to that actually in a moment. I think it's plausible, I'm not saying this is sort of definite in any way, that judges may take the language of rights more seriously. So if we have two examples, first we have a statute that says it is prohibited to afflict animals with unnecessary suffering. It's interpreted, so we will get norm like this. It's plausible that if the statute instead says animals have the right not to be subjected to unnecessary suffering, that the resulting norm will be more encompassing, that they will take it more seriously. I think it's plausible, but of course this is an empirical question ultimately. I think also law has symbolic effect, that's why we have such big debates about the meanings of legal terms. So here is maybe one example, the French gay marriage law from like 12 years ago. Because this, at this point, there was already a civil partnership that included most of the rights associated with marriage. There was one big difference, which was whether you could adopt children. But I think mostly this was about the symbolic effect of whether you're allowed to use the word marriage with regard to same-sex couples. And I think this can apply to animals as well, that talk of animal rights can have a symbolic effect, like a broader effect on the society. And I'll just end, this is an article I made some years ago, an argument I made in an article some years ago with the example of a habeas corpus trial. So here we have I think this is Tommy when he was imprisoned. So there are like two different ways of arguing for habeas corpus. And one is that you argue that animals currently have no legal rights, and the judges are granting the animals their very first right. So this is basically like changing the legal landscape. Like for millennia, these animals had no rights at all, but now this district judge is supposed to change that. And this sounds to me like a very momentous decision, and it might be a big hurdle for a judge to overcome. And if you frame it in this way, there will easily be a lot of debate, these debates that I think many people are very tired of, which is things like, well, can animals even hold rights? And if you give them rights, should they then bear duties as well? And these kinds of debates, which you can see in some of the judgments actually. But if you instead claim that animals already hold legal rights, and we should give them this right as well, of course it's still a very important decision for the judge, but it's not quite as momentous. And you sort of sidestep the question of, should animals then be bearing duties as well, and blah, blah, blah. You don't need to sort of address that question in the same way, because animals have already sort of entered the room of rights. So the debate then is about not whether rights, but what rights animals should have. So summing up, the idea of simple rights, I've argued, has a long pedigree, and some scholars have applied this idea to animals already relatively early. I should say that the idea of rights even is relatively recent. So the simple rights is of course only a couple of 100 years old, but it's not like recent in any way. And there is no obvious reason why fundamental rights would be theoretically more important, like more important for our theorizing about rights. But this is not to say that simple rights would not be sort of insufficient as they stand for animals. And we humans also have various simple rights, and they are often imperfect in various ways. So thanks so much, and I look forward to discussion.